And thank you for coming. Is there anything in Bill 494 that is currently designed, which will have protected you from the $250 that $250,000 that the court order that you were arrested? Anything in this bill that will protect you from?
The answer is based upon the judicial authority that's been appropriated to the court to enter orders for payment of any kind, of any size, based upon the ability to pay, regardless of what the consequences are of that determination. There is nothing in this bill that provides relief for anyone from the kinds of fees that were assessed to me. Just because I worked a lifetime, to put aside those assets, that I believe that we have a legitimate Fourth Amendment claim to say that this is an unlawful seizure of our assets, to basically make us pay for unregulated services in this state is criminal conduct.
Okay.
And we have no protection against that racketeering. None.
Okay.
And it's wrong.
You indicate in your oral testimony that the authority to appoint a guardian ad litem in family court is not defined by law. Could you explain how this judicial authority was acquired then, and how does that relate to Bill 494?
Right. From the best assessment that can be put together based upon public records that I acquired underneath the Freedom of Information Act. And this is published on what's known as a Pathfinder on the judiciary's website itself, that there's a section in there that talks about guardian ad litems. Nowhere in the legislative review that's done by the legal law librarian for the judiciary of the state of Connecticut, is there any statutory language that exists currently that would allow a judge to appoint a guardian ad litem except in juvenile cases and probate cases? What we determined, and I spent a lot of time fighting through the Freedom of Information Act to get access to the public documents, that starting in 2007, on June the 29th, 2007, an email was sent by Justice Peter Zarella on the Supreme Court to judges of the family court that meet for an annual judges meeting. On page 32 of the minutes of the meeting that's public, on June the 29th, 2007, it is referenced that Justice Zarella sent around an email to the judges who passed a resolution by unanimous consent on that day, and that would have included, by the way, Judge Solomon and Judge Carroll, who were in attendance that day, who are no longer here. And what did they do? They gave the authority for the members of the Rules Committee and members of the Supreme Court to start meeting in clandestine meetings to approve practice book rules in this state without this committee being sent, as is required by Connecticut General Statute 51-14B, to hold hearings on the subject of practice book rules in this state before they could be adopted. This committee itself, and understanding, with due respect, not everyone sitting on this committee today was a member in 2007 of when a seditious conspiracy started to occur, which I spoke about on February the 17th of 2012. And what was the response from the co-chairs of this committee? When I came back the following Tuesday, I became the first person ever arrested in the history of this legislature for speaking beyond the 3-minute time limit. Why? Because the co-chairs of this committee wanted to silence me. I could not enter into this building without permission to enter into this building, and became the only citizen in this state ever required to do so. Why? Because the co-chairs of this committee knew that I was right. I quoted from the law. The law says that at the beginning of every legislative session, that the Chief Justice of the Supreme Court shall supply to the Speaker of the House and the President of the Senate the proposed practice book rules that the judges want to have considered. And this committee is supposed to hold public hearings for the purposes of the review. What did they do? A bunch of lawyers who are ranking members, including you, sir, Senator Kissel, because I have the letters from Justice Zarella and Chief Justice Chase Rogers. I have the letters that I acquired under the Freedom of Information Act that invited you into clandestine meetings to be conducted in the attorney's conference room adjacent to the Supreme Court chambers to review the practice book rules, to basically deny the public the ability to have hearings on the subject of the practice book rules, which gets exactly to your question. In 2007, that's how Connecticut Practice Book Rule 25-62, which gave the authority to the court upon motion or sui sponte, meaning upon the court's own motion, to appoint a GAL in this state. That's where the authority came from. It is an unlawful act, and all this legislation would do was to basically establish a right that was accomplished through a practice book rule for which there exists no statutory authority in the family courts to appoint a GAL, yet it's been going on for years. You should all be ashamed of yourselves as the co-chairs who basically have been going to these meetings, but you have no shame.
Sir, I got a couple of other questions, and I don't know, maybe some other members here. Do you went pro se?
I was self-represented at that point in time. Yeah, I did,
Okay.
and the discrimination is incredible.
Okay. Do you believe that you got a fair treatment?
Absolutely not. Let me explain to you what was occurring. Is that I had filed a motion for modification on children's related expenses based upon a substantial change of circumstances in the party's income between the two parents. I needed an adjustment because my ex-spouse was making as much money as I was, and I was paying 65% of the agreed-upon expenses. I was receiving a fair hearing by trial judge referee Stanley Novak in Stanford. We were 5 hearings in. And suddenly, because the lawyer wasn't happy with the way the proceeding was going because I was being treated fairly, what did he do? He went behind closed doors, went to the chief presiding judge, Mary Louise Schofield in Stanford, and asked that that be declared a mistrial. There is no statutory authority that allows a presiding judge to come in this state and declare a mistrial for another judge. Only the judge that's presiding can declare a mistrial. But that's not what occurred. So what happens? There was all sorts of discovery motions, foreign dividend income on my ex-wife's tax return, not declared on her financial affidavit. And what did the judge do after I filed a judicial grievance, indicating she was hiding the evidence of federal tax fraud? She stripped me of my rights to my children 10 days after that judicial complaint was filed. You want to talk about retaliation? You want to talk about a misuse and abuse of judicial conduct by a judge? You need to look no further than my case. And for Judge Elliott Solomon to sit here today suggesting that there aren't problems in the family court system in this state when somebody can go behind closed doors to accomplish a mistrial? You got problems, big problems. And what it has to do with are the 2 most dangerous words in the English language. And they are judicial discretion.
Mr. Nowacki, did you attempt to remove your AMC's guardian ad litem? Do you attempt to do that?
Absolutely. What happened was when the AMC was appointed in the case, and this was on June the 3rd of 2009, and by the way, this is a post-judgment case. In other words, I'm already divorced. I already have custody of my kids. Okay, what does the AMC do? She files an emergency ex parte order with the court to remove my custody rights without a hearing? She had no right to do so. So what did I do? I filed what's called an instant appeal with the Supreme Court of this state underneath Connecticut General Statute 52-265A, saying that this AMC operated outside of her authority as a court appointee. She has no right to file a motion, and particularly in light of the fact that My children were never consulted about what she filed. What did I do? After 16 months, I filed what's known as a writ of mandamus with the Supreme Court of this state, and suddenly my trial was moved to Middletown, and suddenly then, 18 months after my custody rights were restored, my custody rights were restored. What's wrong with this? Ex parte proceedings or whatever are supposed to be in the case of abuse or neglect by a parent. Not for fit parents. Not by an AMC that operated. And why did she do it? To establish the basis for her legal practice at By Pollock, Blue Heights, and Mulcahy, where she had just moved in July. That's what it had to do with. What can I get away with?
We heard Judge Solomon before that he said that they didn't want to call kids to testify. They don't want them to go through that. What your opinion? Do your kids they were willing to testify? What do your opinion about that?
At my custody trial, my daughter was so apoplectic about the misrepresentation, and at that point in time, she's now 15 years old. She wanted to testify. I filed a subpoena with the family court judge to have my daughter testify, and he refused to sign it. Why? Because he knew that there was no informed consent to pursue what was being done. It would have exposed the AMC to legal malpractice, but no. In this state, despite Title 42, Section 1983, which says that no state shall provide an immunity to a class of citizens, GALs and AMCs are a class of citizens who have been protected by the Supreme Court from the abuse of the rules of professional conduct in this state, and it is going to stop.
Okay, and my last question is, could you please indicate what kind of changes and enforcement session will be needed to the rule of the professional conduct to prevent children from misrepresentation by the court-appointed counsel?
I believe that the only thing is going to stop this practice is to put into the rules of professional conduct that any attorney that operates outside of the informed consent of their minor children is subject to disbarment if they do so. You want to bring it into this process, you must have an enforcement criteria that will stop the practice. Otherwise, we have no recourse whatsoever. None. Because the judge can turn down, believe me, I filed motions to remove the AMC, both in Stamford and Middletown. They wouldn't even hear me at that point in time because they removed my right of self-representation, believe it or not. How can you do that? The Sixth Amendment of the Constitution doesn't allow it. Then, 8 months later, a new judge gets assigned to the case and he vacates the order and allows me to represent myself. 8 months. I'm in legal limbo. It's unbelievable what went on. But Elliot Solomon and Patrick Carroll sit here today and deliver testimony suggesting that, oh no, there aren't any real problems in the family court system in this state. You know what? There's a good reason why it was snowing today. That was a snow job here this morning.
Are you all set, Representative Gonzalez?
Yes, thank you.
Thank you. Representative Holder Winfield. Senator Holder Winfield.
It's okay.
I'm going to get it right before the end of the session, I'm sure.
Good afternoon, Mr. Nowacki. First, let me, and I'm asking you this because I really want to make sure I understand you, and I know that you've been here before, and some